Welcome to this deep dive. Today we're looking at a stack of court documents and legal analyses surrounding a really fascinating April 2026 Indian Supreme Court judgment. It is the state of Kerala versus M. Vijayakumar.
Yes, this is a very interesting and landmark and case to dig into and tease apart piece by piece.
Right. And our mission today is to figure out exactly where the law draws the line between, a tight corporate budget and unconstitutional discrimination.
Exactly. It's about establishing the tipping point between pleas of financial Armageddon and the constitutional primacy.
So, to get us started, imagine you walk into a store to buy an umbrella. The cashier takes one look at you and says, "Oh, you are retired. That'll be 20% extra."
What? Yes, that would be infuriating.
Right? Even though the rain pouring down outside hits everyone exactly the same, you're paying more just because you are no longer working. I mean, how is that fair?
Well, it sounds completely absurd and arbitrary. But compensating people differently for the exact same environmental condition is really at the heart of this entire Supreme Court dispute.
Because in our real world case, the drain is inflation. Back in March 2021, the Kerala State Road Transport Corporation or KSRTC handed out an inflation allowance hike to help their people deal with rising prices.
Yes, and before we look at the numbers, it helps to understand how these allowances actually function in the Indian public sector.
Okay, lay it out for us.
So, salaries and pensions usually have a base amount, right? But they also include separate line items. There is dearness allowance for active employees and dearness relief for pensioners.
Got it. So, two different buckets.
Exactly. And these are not merit bonuses at all. They are specifically calculated percentages added to paychecks to, cushion the blow of the rising cost of living.
Okay, so KSRTC decided to adjust these inflation buffers. They gave their active serving employees a 14% hike in dearness allowance.
Which is a decent bump.
Yes. But for the retired pensioners, they only gave an 11% hike in dearness relief. So the retirees understandably flagged this as totally unfair.
Absolutely. That's what it looks and feels like.
But wait, put yourself in the shoes of the KSRTC accountants for a second.
Okay, sure.
The corporation was facing a massive resource crunch. Like, if they are bleeding money, isn't it just pragmatic to say, we are broke? Active workers are a different class, so we have to prioritize the active workers, keeping the buses running over the retirees.
Well, you are hitting on exactly the state's primary argument there. And, they actually brought in substantial legal precedent to back that up.
Wait, really? The courts bought that defense before?
Oh, yes. They pointed to previous Supreme Court cases where severe financial constraints allowed the government to legally modify payouts.
Oh, interesting. So the receipts the government brought worked.
Yes, for example, courts have previously upheld decisions where governments set strict cutoff dates for new pension benefits or even deferred payments entirely.
Just because the state treasury was running dry.
Exactly. But see, the stumbling block for KSRTC here is Article 14 of the Indian Constitution.
Right? Which guarantees equality before the law.
Yes. Now, Article 14 doesn't mean you can never separate people into categories like active workers and retirees. That is allowed.
Sure, that makes sense. Different roles, different rules.
But what it does require is that, well, if you treat two groups differently, the reason for separating them has to directly solve the specific problem you are addressing.
Okay. So, in legal terms, the classification has to have a rational connection to the goal.
You got it. You can't just draw an arbitrary line between people to save a few dollars.
So, what does this all mean for the KSRTC? Like, how did the Supreme Court dismantle their precarious financial argument here?
Well, the court looked at the specific goal of dearness allowance and dearness relief.
Yes. And what happened?
The court determined the singular objective of both allowances is to mitigate inflation.
Right? That was the de facto goal.
And as they pointed out, inflation hits both serving and retired employees with equal force, not disproportionately.
I mean, yes, a loaf of bread doesn't cost less just because you've retired.
Exactly. Because the problem of rising prices affects both groups identically. Paying them different relief rates doesn't actually connect to the goal of fighting that inflation.
The math of the solution has to match the reality of the problem.
You nailed it. The Supreme Court ultimately dismissed the state's appeals based on that very logic.
Wow, so the we are broke excuse just fell apart.
Pretty much. The bench ruled that a financial crunch can certainly justify deferring benefits entirely for a later date, when the treasury is full again.
Right? That is what those earlier precedents were about. Deferring, not discriminating.
Yes. But once an employer makes the active decision to pay out an inflation linked allowance, they cannot arbitrarily give retirees a lower rate.
So, the we are broke defense doesn't give you a free pass to apply a solution unequally if the underlying hardship is identical.
Precisely. It is a very clear line in the sand.
That really shifts the perspective on how equality works in these financial decisions. It isn't just about whether an organization has the funds, right?
No, not at all.
It is about ensuring the specific rule actually matches the real world problem it is trying to solve.
And when you look at the broader implications, it leaves us with a really interesting precedent regarding economic relief.
Which makes me wonder if the court established that inflation hits everyone with equal force regardless of employment status, could this legal logic eventually be used to challenge like other age-based or income-based government economic reliefs?
Oh, that is a huge question. It could open a lot of doors.
If the economic storm affects everyone equally, maybe the umbrella needs to be exactly the same size for everyone, which touches on the central point of the MC Singla case and pension updation. Could the Supreme Court of Justices Nath and Mehta apply the same reasoning in this case?
That remains to be seen as the case comes up for hearing today, but definitely something to chew on. Thanks for joining us on this deep dive. Please like, mention, subscribe, and share this podcast, and we will catch you next time.